The Supreme Court just handed down not one but two unanimous 9-0 decisions that are going to change the way every gun owner in this country thinks about police encounters. Not some of them, not most of them, every single one of you. And if you own a firearm and you have not heard about both of these rulings yet, you are already operating in the dark, because the people who need to know this information most are the people who are least likely to hear it in the mainstream news cycle. That is exactly why you are here. Before we go any further, do yourself one favor right now and hit that subscribe button. Because the legal landscape is shifting faster than most people can track, and I break it down every single time it moves. You do not want to be the last person in your circle to find out your rights just changed. Hit subscribe, then come back. Because what I'm about to explain could determine what happens the next time a police officer walks up to your car window or knocks on your front door. Let me start with what most people get completely wrong about the Supreme Court. They think rulings only matter for criminals. They think constitutional law lives in courtrooms and law school textbooks and nowhere else. That is one of the most dangerous assumptions a gun owner can make. Because the Fourth Amendment is not an abstract legal theory. It is the exact rule that governs what an officer can do to you on a Tuesday afternoon during a routine traffic stop. It governs what happens when someone calls 911 about your house. It governs what you are required to say and what you are absolutely not required to say. And the Supreme Court just clarified both of those frameworks in ways that every person with a firearm needs to understand before their next encounter with law enforcement. So let us start with the first ruling. The case is Barnes versus Felix, 9-0. Decided May 15th, 2025. Written by Justice Elena Kagan for a unanimous court. Here is what happened. On April 28, 2016, a Harris County toll enforcement officer named Roberto Felix pulled over a 24-year-old man named Ashtian Barnes on the Sam Houston Tollway in Houston, Texas. The stop was over unpaid toll violations, not a violent crime, not a weapons charge, a toll violation. Felix asked Barnes for his license and proof of insurance. Barnes said he did not have his license and that the car was a rental in his girlfriend's name. While they were talking, Barnes was rummaging through papers in the car. Felix told him to stop. Then Felix ordered Barnes to exit the vehicle. Instead of getting out, Barnes restarted the car. What happened next lasted approximately 5 seconds. Felix unholstered his weapon, jumped onto the doorsill of the moving car, fired 2 shots blindly through the roof without being able to see inside, and Ashtian Barnes was killed. Now here's where this becomes your problem, not just his family's problem. The district court threw out the excessive force lawsuit. The Fifth Circuit upheld that decision, and the legal theory they used to do it is the theory that should make every gun owner in America deeply uncomfortable. It is called the moment of threat doctrine. And for years, this doctrine operated as a legal shield for officers across multiple circuits. The idea was simple. When a court evaluates whether an officer used excessive force, it only looks at the precise moment the officer felt threatened. Just those final seconds. Just that snapshot in time. Everything that came before it is irrelevant. The officer made bad decisions that escalated the situation? Not considered. The officer jumped onto a moving vehicle voluntarily? Not considered. The reason for the stop was a minor infraction? Not considered. Only that frozen moment where the trigger was pulled. You need to stop and think about what that means for you as a gun owner. Because this doctrine was not some technical theory argued in abstract cases about strangers. It was the framework courts were using to evaluate what happens when you are involved in a police encounter and things go wrong. And things can go wrong without you doing anything illegal. They can go wrong because of a misunderstanding, because of a scared officer, because of a situation that escalated in seconds without anyone intending it to. Under the moment of threat doctrine, none of the context that got you there mattered at all. The Supreme Court said enough. All 9 justices agreed. The moment of threat doctrine improperly narrows the Fourth Amendment analysis. Justice Kagan wrote that the totality of the circumstances inquiry into a use of force has no time limit. Read that again. No time limit. Courts must now look at everything. The full context. What happened before the critical moment, what the officer did to create or escalate the situation, what the severity of the underlying reason for the stop actually was. The court said what lower courts had been doing amounted to putting on chronological blinders, and they said the Constitution does not allow that. Here is where your rights as a gun owner get directly connected to this ruling, and this is the part most people are not talking about yet. The moment of threat doctrine was dangerous, not only because it shielded officers from accountability, it was dangerous because it stripped every layer of context from the encounter, and context context is everything for a lawful gun owner. When an officer stops you, the fact that you are a licensed concealed carrier matters. The fact that you were cooperative matters. The fact that you informed the officer according to your state's duty to inform laws matters. The fact that nothing about your behavior was threatening or erratic matters. All of that is context. All of that is part of the totality of the circumstances. Under the old doctrine, if a split-second decision went wrong, none of that mattered. Under Barnes versus Felix, it all matters now. Every prior second of that encounter is back on the legal record. Before I keep going, I want you to hear this clearly. This is not legal advice. I am breaking down these rulings so you understand the general framework. Your specific situation depends on your state's laws, your jurisdiction, and the specific facts of any encounter you experience. For your own situation, always consult a licensed attorney. What I can give you here is the big picture. And right now, the big picture just got significantly more favorable for law-abiding gun owners. Now here's the part that connects directly to how you behave during a stop. Pay close attention, because understanding Barnes versus Felix is only half of what you need to know today. The second ruling is where most people are going to feel the ground shift underneath them, and it hits even closer to home. Literally. I am talking about your front door. I am talking about the scenario that gun owners almost never prepare for, because everyone prepares for the traffic stop. Everyone thinks about the officer at the window. Almost nobody thinks about the knock at the door from an officer who says they are there to help. The second case is called Case versus Montana. 9-0 again. Decided January 14th, 2026. Written by Justice Kagan again for a unanimous court. Here's what happened. William Trevor Case was at home in Anaconda, Montana. His ex-girlfriend called 911 and reported that he was threatening suicide and that during the call she heard what sounded like a gun being cocked, followed by a loud pop, and then silence. Officers arrived at Case's home. They knocked. They yelled through an open window. No response. Through the window they could see an empty handgun holster and what appeared to be a suicide note. They made the decision to enter the home without a warrant. When they approached a bedroom closet where Case was hiding, Case threw open the curtain, holding an object that looked like a gun. An officer fired. Case was shot in the abdomen, but survived. He was then charged with assaulting a police officer. And he challenged the entire encounter by arguing the warrantless entry violated his Fourth Amendment rights. Let me tell you why this case matters for gun owners in a way that cuts right to the heart of your daily life. This was a man in his own home, a man who had committed no crime, a man whose ex-girlfriend made a 911 call based on what she thought she heard, and officers entered his home without a warrant and without his consent. His legal challenge asked the Supreme Court to require that officers meet a probable cause standard before entering a home under what is called the emergency aid exception to the warrant requirement. 9 justices disagreed. The court held that under the emergency aid exception, officers do not need probable cause to enter your home. They need what the court calls an objectively reasonable basis for believing someone inside is seriously injured or imminently threatened with serious harm. The court was clear. That standard is higher than reasonable suspicion, which applies to brief street stops. But it is lower than probable cause, which typically applies to criminal investigations. It sits in a middle zone, and that matters enormously for you. Think about what that looks like in practice. You are home on a Saturday afternoon. You and your spouse have a loud argument that a neighbor overhears. The neighbor calls 911. When officers arrive, your spouse has stepped out and you do not answer the door because you do not know anyone is there. The officers see through your window that you have a gun safe and what might be, to an untrained eye, a cleaning kit laid out on a table. Under Case versus Montana, if officers have what they believe is an objectively reasonable basis to think someone inside needs emergency aid, they can enter, without a warrant, without your consent. And here's the critical part for anyone who legally owns firearms. What happens in that encounter when you emerge from another room not knowing officers are in your home? What happens when you are holding your lawfully owned firearm because you thought you were alone and heard movement? Context collapses. Seconds matter. And the encounter can escalate in exactly the way Barnes versus Felix was designed to evaluate after the fact. This is where these two rulings connect, and why understanding both of them together is so critical. Barnes versus Felix expands how courts evaluate what happened during an encounter after the fact. Case versus Montana affects the conditions under which that encounter begins in the first place. One governs what gets examined, the other governs the threshold for the encounter to start. Together, they define the legal landscape of your home and your vehicle in ways that directly affect every person who keeps a firearm for lawful purposes. If you are finding this helpful right now, I need you to do one thing. Go hit that subscribe button if you have not already, because in my next video, I am breaking down the 5 exact words you need to say when an officer asks about your gun during a traffic stop. 5 words that are simple, legal, and that courts have consistently recognized as an invocation of your rights. You do not want to figure those words out after you are already in the back of a patrol car. Subscribe and turn on notifications so you do not miss it the second it drops. Let us go deeper on what Case versus Montana means for your specific setup as a gun owner. Because this ruling does not just affect people in crisis. It affects every gun owner whose neighbor, ex-partner, or even a well-meaning family member might ever call 911 with concern about what they thought they saw or heard. Consider how the emergency aid exception works now. An officer does not need a warrant. They need an objectively reasonable belief. That belief can be based on a 911 call from someone who has never been inside your home. It can be based on what an officer sees through your window. It can be based on your failure to respond to knocking, combined with anything in their field of view that suggests something might be wrong. The court also acknowledged that the entry must be limited in scope. Officers cannot use an emergency aid entry to conduct a general search of your home. They are supposed to limit themselves to what is reasonably necessary to address the apparent emergency. The court was explicit. The emergency aid exception provides no basis to search the premises beyond what is reasonably needed to deal with the emergency while maintaining officer safety. But here's the problem. The ruling itself does not fully resolve. The moment officers enter under an emergency aid theory and discover a firearm in the open or observe something they interpret as evidence of a crime, the legal situation shifts. What started as a welfare check can transform into something else entirely. And once officers are inside your home, the legal protections you thought surrounded your firearms become significantly more complicated to invoke. This is why preparation is not just a legal strategy, it is a safety strategy, for you and for your family. Let me give you a scenario, not a real case, a composite illustration to help you understand how this plays out in the real world. Imagine a gun owner. Call him David. David is a responsible concealed carrier. He owns 3 legally purchased firearms. He keeps them stored properly. He has no criminal record. On a weeknight, David and his adult son have a heated disagreement that gets loud. A neighbor hears it and calls 911. When officers arrive, David's son has left. David did not hear the knock over his television. The officers see through a window that David is visible, seated, and does not appear injured, but they also notice what looks like a firearm on the coffee table. Based on the 911 call and what they observe, they make the decision to enter without a warrant under Case versus Montana's emergency aid exception. David hears the door open and instinctively reaches for the firearm because he believes someone has broken into his home. The entire encounter now depends on what happens in the next 3 seconds. And what happens in those 3 seconds will be evaluated by courts under the totality of the circumstances framework that Barnes versus Felix established. That is why these 2 rulings must be understood as a system. Not as 2 separate, isolated legal events. They are the before and during of the same encounter. Case versus Montana gets officers in the door. Barnes versus Felix governs how everything that follows gets evaluated. Your knowledge of both of them is what determines whether you make decisions in that moment that help you or decisions that hurt you. Now let me address the Fifth Amendment dimension directly, because there is something that happens in these encounters that most gun owners never think about until it is too late. The moment officers are inside your home, or the moment you are detained at a traffic stop, the question of what you say and what you do not say becomes critically important. The Fifth Amendment protects you from being compelled to incriminate yourself. That protection does not begin at your trial. It begins the moment you are in a situation where your words could be used against you. It begins in your living room when an officer who entered under an emergency aid theory starts asking you questions while standing in front of your legally owned firearms. It begins at that traffic stop when an officer asks if you have any weapons in the vehicle and you feel pressure to explain yourself. Here is what most people get wrong about silence. They think staying quiet makes them look guilty. They think it is something only criminals do, but the bedrock constitutional principle remains intact. You cannot be forced to speak. You cannot be penalized for exercising a constitutional right. And there are specific ways to invoke your right to remain silent that carry more legal weight than simply saying nothing. The key word is properly, because how you invoke your rights matters as much as the fact that you invoke them at all. The clearest lesson here comes from examining cases where people handed prosecutors their entire case through honest but legally harmful answers. When someone tells an officer about their firearm without being required to under their state's duty to inform law, when someone explains where they are coming from when they have no legal obligation to answer, when someone confirms what is in their home without understanding that confirmation can be used as evidence, they are doing the government's work for them. Your permit gives you the right to carry. Your silence gives you the right to stay free. I'm going to do a dedicated video on exactly how to invoke your Fifth Amendment rights during both a traffic stop and a home encounter, because the mechanics of how you do it matter as much as the fact that you do it. Subscribe and turn on notifications so you are the first to know when that drops. This is some of the most practically significant information I have ever put together for this channel. Let us talk about what you should actually do right now, today, in response to these two rulings. First, learn your state's duty to inform laws. Some states legally require you to tell an officer about your firearm when you are stopped. Others do not. Barnes v. Felix does not change those state laws. What it does is change how the broader context of your encounter gets evaluated afterward. Knowing your state's specific rules is still the foundation of every traffic stop interaction. If you do not know your state's duty to inform law off the top of your head, that is your first homework assignment before you finish watching this video. Second, take a serious look at your home's exterior from the street. That sounds unusual, but think about it. What is visible through your front window? What is visible through a side window? Case v. Montana makes clear that what officers can observe from a lawful vantage point factors into whether their belief that something is wrong is objectively reasonable. If your firearms are visible from outside and a neighbor calls in a noise complaint, that combination gives officers more factual basis to justify entry. That does not mean you have done anything wrong. It means you should be thoughtful about visibility, not to hide lawful activity, but to reduce the risk of a misread situation. Third, have a plan for how your household responds if officers knock and there is no emergency. Know how and where your firearms are stored in a way that does not create unnecessary alarm. Have a calm, clear verbal response ready. Something as simple as stepping to a window, identifying that officers are present, and communicating through the door that you are present and safe can change the entire trajectory of a welfare check encounter. Officers who hear a calm verbal response indicating the resident is alert and uninjured have less basis to claim an objectively reasonable emergency existed. That matters directly under Case v. Montana. Fourth, save the number of a criminal defense attorney who handles Second Amendment and Fourth Amendment matters in your state. Not a general attorney, someone who specifically handles the intersection of these constitutional areas. If you are ever in an encounter where officers enter your home, one of the most legally significant things you can say at any point in that encounter is that you would like to speak to your attorney before answering any questions. That invocation, made clearly and unambiguously, triggers important legal protections. Have the number before you need it. Do not try to locate a qualified attorney while your hands are shaking and officers are standing in your living room. Fifth, document your compliance. If you are a legal gun owner, keep a simple file that includes your permit, your purchase records, and a clear record of any relevant training you have completed. Having these ready does not make you look guilty. It makes you look like a responsible, informed citizen. And in any encounter that escalates into a legal proceeding, your documented history of lawful, responsible ownership becomes part of the context that courts are now required to examine under the Barnes v. Felix totality standard. Here is the broader picture that ties all of this together. The Supreme Court has now, in two unanimous decisions issued less than a year apart, clarified the constitutional framework governing police encounters in both vehicles and homes. Barnes v. Felix restored contextual fairness to how use of force claims get evaluated. It ended a doctrine that stripped away everything but the final moment. And while that restoration matters for accountability when things go wrong, it also reestablishes something every lawful gun owner needs to remember. Your behavior throughout the entire encounter matters, not just the last 3 seconds. Everything you did from the moment the stop began, the way you communicated, the way you positioned your hands, the way you identified your firearm, all of it is back on the table. All of it is now part of the legal record that a court can examine. Case v. Montana, on the other hand, confirmed something that gun owners have to absorb even though it is uncomfortable. Your home is not a perfect fortress against entry. The emergency aid exception has always existed. But this ruling defined its standard clearly for the first time in a unified national framework. Lower than probable cause, higher than reasonable suspicion, an objectively reasonable basis to believe serious harm is occurring or imminent. That is the threshold. Knowing it exists does not mean you have lost anything. It means you now know exactly what you are working with, and knowledge of the actual legal framework is always better than a false sense of absolute protection. Stay with this channel, because the legal picture being drawn by these rulings has layers that courts are still unpacking. There are live questions about how Case v. Montana interacts with red flag laws in states that have them. There are questions about how the expanded totality analysis from Barnes v. Felix will ripple through lower courts over the next several years. There are questions about what happens when officers enter under an emergency aid theory and discover evidence of a crime that is completely unrelated to what brought them there. These are not hypothetical concerns. They are active legal questions being litigated right now, and every one of those questions has direct implications for gun owners specifically, because firearms are visible, because firearms can be misread, because the intersection of mental health calls, neighborhood disputes, and lawfully owned weapons is precisely where these two rulings will do the most consequential work. Subscribe to this channel. Share this video with every gun owner in your life who does not follow this space closely, because the people most at risk from not understanding these rulings are the people doing everything right. The people with the permits, the safes, the training, the lawful purchases. Those are the people who deserve to understand exactly what legal framework now surrounds their rights. That is what we do here. We take the decisions that 9 justices hand down in formal legal opinions, and we translate them into the practical knowledge that keeps law-abiding Americans free. Thank you for being here. Thank you for taking your rights seriously enough to spend time understanding them. Stay informed, stay prepared, and we will see you in the next one.